Good afternoon. My name is gkg.legal and I'm a practicing lawyer at Kuala Lumpur, Malaysia. Today I shall speak to you about force majeure and its effect on the coronavirus pandemic. Suppose you were a person who was supposed to supply, say, 1,000 loaves of bread to a supermarket, and because of the pandemic you've been stopped from doing that. What happens to your stock? It's livestock. It will go, it's perishable, and it's going to make life very difficult for you. The supplier wouldn't pay you. You have to get rid of your stock. You have to pay your supplier. Suppose you were an employee and there's a force majeure clause. What happens? Suppose you are an oil supplier and you are supplying oils from the Middle East to, say, for example, in China or Russia, and you cannot dock. Your ship is full of produced oil or cocoa or some other natural product and you can't supply. What happens? Today we will speak about what force majeure does and how it affects you. I basically subdivided this talk into three parts. The first part is an introduction of what force majeure is. How does a force majeure clause sound like? The second is its internal mechanisms and how it works. And the third one is its consequences. Let me start by saying that if you do not have a force majeure clause in your contract, then this entire talk is irrelevant to you. You have to fall back on the common law concept of frustration, a point to which I'll come back in a few minutes. The second point I want to make is, what does force majeure mean? It's an unexpected event. It's when two parties enter into a contract, they had no idea that this was going to happen. Let me give you an example of a force majeure clause. I'll try and keep it as simple as possible. If one party, the clause says, if one party is unable to perform its obligations under this agreement because of causes reasonably beyond its control, and sometimes the clauses will explain what those circumstances are: earthquake, volcanic eruptions, floods. These are all acts of God, natural disasters, or they may speak about man-made disasters, for example, riots, war, strikes, and so forth. Then the clause will say, if any party is unable to perform its obligation under this agreement because of causes reasonably beyond its control, for example, A, B, C, and D, then the party shall not be liable for damages to the other. It may say that. Or it may have a rescue clause or a rescue mechanism. What it means is, there may be within the force majeure clause a mechanism on how the parties will behave during the pandemic. There may be a third problem. It may define earthquake, it may define flood, it may define riot or war. It may say nothing about the coronavirus pandemic. Then what happens? Well, we'll answer the question. The example I've already told you about a force majeure event are, for examples, volcanic eruptions, earthquakes, floods, hurricanes, all natural disasters. Then man-made, riots, strikes, wars. Now you've got the coronavirus pandemic. Where do you fit this in? Is that natural or is that man-made? There's a problem there. I have no doubt that this is an unexpected event, and whether it was man-made or not is irrelevant to the question facing you. The next point I want to make is how this entire mechanism works. I'll tell you how it works. It must have three qualities. The three qualities are externality, unpredictability, and irresistibility. Let me explain. What is externality? Externality means it's outside my control. I had nothing to do with it, says the party who cannot perform. Unpredictability is, I couldn't foresee it. I didn't know it's going to happen. I didn't know. And now we're stuck with it. The third one is irresistibility. Irresistibility means no matter what I did, I couldn't have prevented this event from occurring. If these three tests, externality, unpredictability, and irresistibility, are fulfilled, then you have a force majeure event. I've been repeating this again and again and again. If you have a force majeure clause, it will work. If you don't have a force majeure clause, it will not work. You cannot apply force majeure. You have to fall back on another concept called frustration, to which I will deal with in a few moments. It's very difficult to prove in the normal course of events force majeure, because you've got to prove the three elements. But I have no doubt in my mind that this particular lockdown is a force majeure. You were not in charge of the lockdown, the government was, and the government gave you an order. If you don't lock down, if you don't comply with the movement control order or stay home orders or some other technical term all across Australia, the United Kingdom, South Africa, Holland, Sweden, down in New Zealand, it depends on the term that they use. I'm using the word lockdown. It was instituted by the government. It had nothing to do with you. You couldn't have possibly called the Prime Minister and said, stop it, I want to go to work. Can that be done? No, it's unpredictable. Secondly, it's also irresistible. You couldn't have catered for it. So there are similar legislations all across the world. In fact, there are laws that says in Malaysia there is a law called the Prevention and Control of Infectious Diseases, which prevents you from getting socially close to another person, and you have to keep a particular distance, and that's why they have this lockdown. The hope is by isolating yourself away from people who are infected, you would keep yourself safe, and if you are infected, you would keep other people safe from you. So we now move to the third part of it, advantages and disadvantages. The advantages of having a force majeure clause is it actually excuses you for the duration of the force majeure. If the lockdown is for 2 weeks, then you are excused for 2 weeks. If the lockdown is for 2 months, perhaps you may be excused for 2 months. If the lockdown is for 2 years, people can go to work, restaurants cannot open, you cannot supply raw materials, you cannot take your ship and land in Philippines, then what happens? Then there may be termination. So do not assume that because there is a force majeure clause, therefore you are excused for the entire duration. That may not be the answer. The second advantage is there may be a clause within the force majeure term, an embedded clause, which is called a mechanism, and the mechanism is if force majeure occurs, party A will do X, Y, and Z. For example, if you are sending a ship laden with cocoa, tons and tons and tons of it, and you go on and it says, all right, you can't offload the material in Philippines, then what you do is you go to the nearest port, keep it in storage, and both parties will share the storage cost. There may be such a clause. Then you're okay. If there's no such clause, then you have to take mitigative steps. What are mitigative steps? Steps which will reduce the loss to yourself and to the other side. You can't just fold your hands and say, I don't know anything. That's it. I'm going to idle the ship here. You've got to pay demurrage charges. You're sitting in port. The port master, the harbor master would want you to pay certain charges. He would want you to follow certain rules. You can't offload people or goods from your ship. What about raw materials? What about water that you need? Supplies for your crew. That's if you're a shipper. What if you're a contractor? If you're a subcontractor and you're doing construction business, what happens? You can't supply material and cement to the site. You don't have workers to carry the materials. You don't have men working on the cranes. You have no men working on the machinery. You have done the groundwork. You have done piling of, you've piled and you've put on pile caps and you're about to put on the other superstructure, and the whole thing comes to standstill, and there's material coming to you from the northern part of the country down to the south, and you're supposed to take control of all this material and store them. You cannot do it. There are roadblocks everywhere. What happens? So it depends on what the clauses say, because force majeure clauses are contract specific. If the clauses do not say, then you have to take reasonable steps to limit damages to yourself and to the other side. There was once a case in which a shipper was told you can offload the goods in the nearest port at the market price. So if you are having a particular kind of crude oil in your tanks and it used to be $40 per barrel, it's now $24 per barrel, and you go out there in Philippines and they're prepared to buy it from you at $15 a barrel, you have to think about the losses that you're going to sustain and decide whether you're going to offload, keep it and put it in your own storage at a different cost and sell it later, do calculations, and then you have to do what is the best for yourself and for the other side. The problem, the disadvantage is, A, if you don't have the clause, obviously you have to fall back on common law or general law in your country. For example, if you lived in New Zealand or in Australia, then you would have Acts, Contracts Act. If you lived in India, then you'd have the Contracts Act. If you lived in Malaysia and Singapore, then you would have a particular set of laws. Most of these are laws in relation to the common law jurisdictions. There would be a concept called frustration. We'll deal with that in a minute. The disadvantage of having a mechanism, a repair mechanism within a force majeure clause is you must comply with it. So if it says store the oil, you must store the oil. You can't discharge the oil in mid-sea. You cannot transfer it to another storage. You cannot go and sell it to somebody else. You can't do any of that. You have to follow the mechanisms within the force majeure clause. If there is no mechanism, then you have to take reasonable steps. What are reasonable? It's not what you think is reasonable, it's what the court thinks is reasonable. Now, I have spoken to you about the existence of the force majeure clause. I told you what a force majeure is, unexpected event. I told you how a force majeure clause sounds like. If an unexpected event occurs, then both parties will be released from their obligations and neither party will sue the other party for damages, for example. And to it there may be a rescue or a repair mechanism if parties are caught in a force majeure event. This is how they will behave. A, B, C. Comply with it. I've spoken to you about the advantages. I've spoken to you about the disadvantages. But suppose you don't have a force majeure clause. What do? Well, you have to fall back on the law of frustration. What is frustration? Well, for frustration to occur, three qualities must occur. The first is you must be in a jurisdiction that practices frustration as a matter of law. So if you are in East Asia, you're okay. I cannot tell you what the law is in South Korea, but I assume that there is some level of frustration there. There is no problem in Australia. There is frustration. The law of frustration works there. So also New Zealand, Singapore, Malaysia, Brunei, and various other common law jurisdictions. The second thing is there are three elements in a frustration event. These elements are, it must be a supervening event. It must come into the contract and break the contract. In force majeure we call it external, in common law they call it supervening. Yeah, the coronavirus pandemic is supervening. Second, it must be unforeseen. Neither party would have thought about it. So if neither party would have thought about it, obviously it's unforeseen, and therefore the unforeseeability element is there. The third one is the effect. Force majeure says unforeseen event, and the three tests I told you. What are the three tests? Remember I told you the three tests? Externality, unpredictability, irresistibility. Whereas in frustration, the effect of the supervening event must be to completely change the foundation of the contract. You go and rent a particular theater to run a kind of show for all the days of the month of March and April, and you pay the booking fee for 15 different cities at US $1 million, and then this event happens. There's a pandemic. Nobody wants to go and see your show. What happens to that $1 million that you paid? Well, the entire contract in frustration comes to an end. Both parties are released from their obligations. There's no contract after that. There was a contract before the frustrating event occurred. But the moment the event occurs, the contract is voided. There's no contract after that. neither party needs to perform any of their obligations. So the $1 million that you paid as a deposit must be paid back to you. Unless, of course, the chap who is in charge of who owns the theatres has spent money doing certain things that you asked him for. You want a particular kind of speaker, you want a particular kind of projector, then he has to spend money on it. Those monies cannot be recovered because those were reasonable expenses. Then the frustration clause may exist in a contract, just like a force majeure clause, and it may have consequences. Okay, if a frustration event occurs, this is what we're going to do: A, B, C. If it happens, then make sure you look at the frustration clause and make sure that you follow what they tell you. What's the difference between the consequences of frustration and force majeure? Well, the consequences are, in force majeure, for the duration of the unexpected event, you are released from your obligations depending on the duration. If the duration is for a very long time, if the governments are going to lock the nation down for 2 years, then hardly you can say that the contract exists. But if it's for 2 weeks or 3 weeks or 4 weeks or 6 weeks, it can still be reasonably, assumed that the contract is alive. Whereas in frustration, the contract dies. Neither party has to perform. They stop. Whatever money is paid over to the other side must be paid back. Whatever goods sent to the other side and not paid for should be sent back if they're not perishable. If they're perishable, then arrangements have to be made. If no arrangements have to be made, you have to sue the other party in a normal law of contract. So that, my dear friends, is basically the law of frustration. So let me rehearse with you the number of elements on frustrations that I spoke about. First of all, it must be an external event. It's a supervening event, just like force majeure, externality. The second one, it must be something that neither party had thought about. And force majeure says what? Unforeseeability, doesn't it? It says unpredictability. The third event is, the effect is, it completely changes the foundation of the contract. Suppose you were to enter into a sale and purchase agreement to buy a commercial property that's 20 stories high. You pay the deposit, you sign the contract, you go back and you're supposed to pay the balance purchase price within 3 months, say, and there's an earthquake and the entire building collapses. Then the nature of the supervening event would be to completely alter the foundation of the contract. The material is no longer there. It's impossible to perform the contract. That is frustration. In Malaysia, it's section 57, I think it is, and there are civil law provisions under sections 16, 17 and 18 that deal with it. I don't want to speak about the law. All I want to tell you is, in frustration, the contract comes to an end, both parties are released from their obligations, then whatever money is paid must be paid back. So, we have now come to the end of this talk. I've spoken to you about the effect of force majeure on contracts. I've dealt with different kinds of contracts. For example, if you're a tenant, you rent out 100 units of commercial properties from a main owner, and there's force majeure, and nobody is occupying the premises, then what happens? And there's no force majeure clause. You have no force majeure clause. You have no frustration clause. What happens? Well, back in the 1940s, London was bombed out of shape by the German Luftwaffe. And this period of bombing continued well into April of 1941. And as you know, the case of Liversadge and Anderson was decided sometime in September. But more importantly, in 1944, the tenants had all left because of the bombing. By 1944, they had come back by June, July, August, and the commercial properties had been filled up. One of the landlords, in a case called High Trees, said, "Can I have all the rentals back, please, for the entire duration of the war?" And Lord Denning created the principle of promissory estoppel. He said, "You said to me that you will not collect rentals for the entire duration. Since you said you can't collect, and the law has been altered to that extent, And today the promissory estoppel principle is accepted. But the promissory estoppel principle only applies if there is a representation. If the landlord tells you, look, I will not collect rentals. If you are sitting in a residential property enjoying the benefits of the landlord's largesse, then you tell the landlord, force majeure, frustration, I'm not going to pay you rentals. You know why? Force majeure. That'll be a bit too much, isn't it? But if you are a commercial tenant, you can't access your factories. Your workers cannot access the factory. They cannot use the machinery. Then the whole place is shut down. The police are guarding all the roadblocks and you can't go. Then what happens? And there's no force majeure clause. Is there frustration? Of course there is. But if you use frustration, then what happens is the whole contract dies, and you don't want to kill the contract. Of course you want to go into business. So you would want to think about all these things and go consult your lawyers. Talk to your lawyers and tell them, look, I've got a situation. Those of you who have a force majeure, ask your lawyers, look, there's a force majeure clause here. Does it include coronavirus? I think he should say yes. Then they would ask him, is there a rescue mechanism? A mechanism where the lawyer reads the agreement and says, no, I don't think it's a general clause. Then what's going to happen is he will say, all right, let's take reasonable steps to mitigate and deal with the other side, the opposing party to the contract. So there you have it. I've spoken to you about frustration. I've spoken to you about tenants. I've spoken to you about shippers. I've spoken to you about building contractors. And this brings me to the end of my talk. I want to thank all the people who are behind the Unrestricted Stage Facebook page for giving me this opportunity to speak. I have my own videos on frustration and force majeure, which will be published later. If you want to see more about how frustration works, please go to my website. It's called Paradox, gkg.legal. Don't have to say www.gkg.legal.com. Don't have to say anything. I've designed the website in such a way. It says gkg.legal. You go there. There are 2 or 3 essays. In the description below this particular cast, you will see the 2 links. Please press them, or you can go to Facebook and have a look at it. And by all means, please support Unrestricted Stage. It's a group of very clever entrepreneurs who are doing a great deal of work helping artists. I hope this talk has been helpful to you. I suggest you go to the website and deal with it. If you have any queries, please ask your lawyers. Please have a good day, stay safe, and stay home.